Hello, everyone. Good evening. Good evening, our lovely speakers. Welcome to our webinar series on intellectual property in engineering, science, and technology advanced concepts. And today we have our lovely speakers of the day, Mr. Enrico Bonadio, and we have Ms. May Hassan. Good evening, both of you. And I think it's good afternoon in your country, preferably. Okay. So before we begin, I would like to welcome and thank all the attendees who has joined us today evening. Thank you all for joining our webinar series on intellectual property, engineering, science, and technology. Today we have come up with this another interesting topic, which many of you will be familiar as well as unfamiliar with the term IP, intellectual property, and its role and benefits. Therefore, IFERP has organized a 5-day program starting from today, August 7th, till August 11th on intellectual property to educate our fellow IFERP members as well as the non-members. In these 5 days, we will be discussing on what is intellectual property and what are intellectual property rights, the challenges faced in intellectual property rights, and then on how to handle and manage IP portfolios with focus on engineering, science, and technology. Then we'll be also discussing on patent drafting in the field of engineering, science, and technology, and many more things. And all these 5 days, we have very renowned international speakers who will be accompanying these 5 days. So before we begin, I would like to introduce to you our platform, IFERP, which is Institute for Engineering Research and Publication, which is one of world's largest professional associations operating under Technorate Research and Development Association, meant for research and development in the field of engineering, science, and technology.
Welcome to IFERP, a forum where innovations and research interest could be supported and developed, prioritizing our mutual interest. In this video, we want you to dive into our world, giving yourself a clear insight into IFERP. But first, who are we and what do we do? Institute for Engineering Research and Publication, IFERP for short, is one of the world's largest non-profitable professional associations operating under the Technorate Research and Development Association, TRADA, meant for research and development in the field of engineering, science and technology. We are one of the largest professional bodies for engineering professionals in India and across the globe, established in 2014. We extend to every part of the globe with more than 28,000 professional members and 34,000 student members. Our growing membership at IFERP has led to an increase in members from Europe, Asia, Australia, Africa and the USA, fostering networking opportunities that strengthen ties within and across countries and technical communities. The mission of IFERP is to connect professionals at an integrated platform for growth to divert knowledge and skills towards the sustainable application of professional education and more. And our vision of digitalizing innovation processes through our professional networking services and more has pushed us forward to our achievements today. With our mission to make our academic services reach the top and grassroots level of institutions, we are funding colleges to organize conferences and scientific events, enabling researchers incubated at different areas of our country to directly contribute towards the transformation of India. IFERP simply connects engineers, exchange global innovation, and acts as a bridge between researchers and academics by organizing international conferences, world conferences, faculty development programs, webinars, seminars, providing membership, and more. Some of our conferences include WCASET Malaysia, WCASET Jakarta, ICAS ETAM APU Malaysia, and many more. We've also organised scientific events in association with renowned universities done in the past, with over 28,593 journal publication services, creating opportunities to get your research paper published in high impact factor journals such as Scopus Indexed, Web of Science, Google Scholar Index journals, ESCI, UGC approved, L Compandax, ISI, Shimago Index journals, and many more. To make our operations smoother and more perfect, we have been supported by our associated organization, Association of Cloud Technologists, Global Association of Nanotechnology, International Association for Big Data Analysts, International Association for IoT, International Wireless Network Association, and World Association for Structural Engineers. We have also worked alongside several clients and partners both nationally and internationally like University Malaysia Sabah, APU Malaysia, UNJ Jakarta, MC University Thailand, Ajman University Dubai, PUP Philippines, IIUM Malaysia, ISU Philippines, FCPC Philippines, WCC Philippines SRM University, Galgotia University, Amity University, and much more government and private organizations in different countries. At IFERP, we believe that there's always a better way to treat professionals, and that is what we do. If you would like to see more or go deeper on IFERP, you can visit our website at www.iferp.in.
Thank you all. We have more participants joined, and thank you and welcome to all the participants who are watching us live on YouTube as well. So today we'll be discussing on introduction to intellectual property and intellectual property rights. So before we begin, I would like to introduce to you our speakers of the day. Firstly, I would like to introduce to you our speaker, Ms. May Hassan, who's an intellectual property attorney and a WIPO certified IP trainer, IP field researcher in Egypt. Welcome, ma'am, and thank you for joining us today.
Thank you, it's my pleasure.
Ms. May Hassan obtained her Masters of Law from Seoul National University Law School at South Korea with a focus on intellectual property law and is specialized in legal issues concerning copyright, brand protection and enforcement, media and entertainment law, and intellectual property law. In addition to her experience in IP market surveys, investigations and negotiations with infringers, as well as trademarkers, registration, petitions, and oppositions. She is a licensed trilingual attorney admitted to the Egyptian Bar Association since 2007 and had the privilege to be the attorney of many global well-known companies. Recently, Ms. May Hassan has created IP Mentor Cast to support entrepreneurs and SMEs in order to integrate the intellectual property system effectively into their businesses. So she also spreads the importance of intellectual property for the youth through her creations under IP Mentor Youth Series. As a WIPO certified intellectual property trainer since 2014, she has developed a unique experience in planning and conducting creative training programs, workshops, and seminars in Egypt as well as abroad. She has a genuine interest in working on projects related to intellectual property awareness and capacity building in order to illustrate creatively smart IP tools and strategies that boost and empower the use of the IP system effectively, whether with startups, SMEs, or governmental organizations, or NGOs. She is also a tutor at WIPO Academy, and in 2017, she has been nominated by WIPO as the National Intellectual Property Legal Expert for an IP project under the development sector. And in May 2019, she had the pleasure to present her IP field study research and share it before countries, representatives, and the Committee on Development and Intellectual Property in the 23rd CDIP session in Geneva, Switzerland. Thank you, Ms. May Hassan, and welcome. It's an honor to have you today evening.
Thank you so much. It's my honor as well. It's my pleasure.
And I would like to introduce to you our next speaker of the day, Mr. Enrico Bonadio. Welcome, sir. Thank you for joining today. He is the reader in Intellectual Property Law, City University of London in United Kingdom. Mr. Enrico is he teaches various models on intellectual property law, He holds law degrees from the University of Florence and the University of Pisa, and is associate editor and the intellectual property correspondent of the European Journal of Risk Regulation, as well as member of the editorial board of New Art Journal. Mr. Enrico has recently co-edited the book Non-Conventional Copyright: Do New and Non-Traditional Works Deserve Protection, along with Nicola Lucci and Elga in 2018, and edited the Cambridge Handbook of Copyright in Street Art Graffiti. Mr. Enrico is also researching on IP protection of artificial intelligence and robotics. He is part of a consortium that has been awarded funding by the EU as part of Horizon 2020 to assess the area of interactive robots in society. He also recently authored a report on standard essential patents and the Internet of Things, which was commissioned by the European Parliament. He has also done academic work on academic innovations, geographical indications in the global market, digital copyright and free speech, exhaustion of IP rights and parallel imports, morality and IP, patentability of human embryonic stem cells, and patents and food safety. Mr. Enrico is also a visiting professor at University Catholic de Leon and a visiting lecturer at the WIPO LLMs in Turin, Italy, Ankara, and in Shanghai in China. His research has been covered by CNN, Wall Street Journal, Washington Post, New York Times, Reuters, BBC, The Times, Independent, and The Conversation, amongst other media outlets. He is a solicitor qualified to practice in England and Wales, as well as in Italy. Mr. Enrico practiced as IP attorney for several years in top-tier international law firms. He also regularly joins training and technical assistance missions organized by WIPO. He is also a member of IFERP, that is International Association for the Advancement of Teaching and Research in Intellectual Property. He is also a member of BLAC, which is a British Literary and Artistic Copyright Association, and the Law Society of England and Wales. Thank you so much, sir. We are so grateful to have you both today evening. I'm very sure the audience, the participants are highly thrilled and eagerly awaiting to hear from you. And without any delay, we'll be moving on first. So first we'll move on to Mr. Enrico Bonadio.
Okay, thank you for the presentation. I'm going to share.
Sure.
I'm going to share my screen. So
okay, you want me to play the presentation?
Oh, you will play the presentation, or I will play?
Anyhow, it's fine. It's fine.
Okay, I can.
This one?
Okay, perfect. So you have already. Okay, that's good.
Yes. So you may continue. Yeah, that's good.
Yes. Yeah, I will try to. I will start from patents because I will cover the requirements for protection of intellectual property rights, whereas May will give a more introductory in concepts on intellectual property rights. So I will start from patents instead of trademarks and designs, because it's quite relevant when it comes to engineering, right? So I will start by looking at the patents and confidential information to intellectual property rights that are very important for in the engineering field, let's say. And then I will turn to trademarks and copyright as well. So first of all, I mean, here we talk about, I'm just scrolling down the slides, and just a second. Okay, yes. So as I said, there are several intellectual property rights we talk about today. Patents, which protect technology, confidential information, trade secrets, which protect still technology or information that are not protected by patents. And then we have copyright, which protects literary, artistic, and also musical works, amongst other works, and then trademarks, which protect brands, signs, which distinguish products. And also I will mention design rights, which protect the ornamental features of products. But let's start with the patents, right? Patents which protect technology, right? Which is very important when it comes to the field of engineering. Because of course engineering has to do with technology. So in my presentation, I will look at the requirements for protection. What do an applicant need to do in order to get patent protection? This is a kind of intellectual property right acquired by registration, by a procedure. So basically, a patent application is filed with the local patent office, could be the US patent office, the Indian patent office, the European patent office. And so a procedure starts, right? It's a kind of registered right. You file an application for obtaining a patent. And the invention will be patented if certain requirements are met. In particular, novelty requirement, the inventive step requirement, as we know it in Europe. In the US, it's called non-obviousness requirement, and the industrial application requirement. We will focus more on the first two important substantive requirements, novelty and inventive step. An invention will be patented in any patent office if it is new, which means if it doesn't belong to the state of the art. It means that the invention will be patented if someone else has not come up with the same invention before the filing date, the filing of the application. So from a substantive perspective, novelty means that the invention does not belong to the state of the art, right? So, for example, if you look at the European Patent Convention, this provision is quite clear. It says, the invention shall be considered new if it does not form part of the state of the art. The state of the art shall be considered to comprise everything made available to the public by means of a written or oral description, by use, or any other way. What does it mean? If someone else, as I said before, has come up with the same invention 10 years before, of course, the new invention is not new, so it will not be patented because the novelty is destroyed by the previous disclosure, by someone else who has invented and published the invention. For example, published it in a journal, no? In a scientific journal, for example. Not only that, even the applicant who files for a patent application must be sure that he has not disclosed the invention in question before the filing date. So, for example, in my professional experience, I heard about clients coming to me and asking, look, I have come up with this invention and I want to patent it, right? I want to file patent applications in several countries of the world. But 3 years ago, I have presented it at a trade fair somewhere in the world. And of course, this is not good because if you have disclosed the invention before filing for a patent application, you cannot obtain the patent. The patent will be refused for lack of novelty because there has been a prior disclosure, right? What about the second important requirement, inventive step, which in America and the US is also known as non-obviousness? An invention shall be considered as not be inventive, not satisfying the inventive step requirement, if it is obvious to a person skilled in the art. This is the inventive step requirement. the invention must not be obvious to a person skilled in the art. If it is obvious to a person skilled in the art, that means that the invention will not be patented. How can a patent office examine, assess the inventive step requirement? In Europe, what has been done many times by patent offices, the European Patent Office, for example, is to adopt this approach, the problem-solution approach. In general, an invention is defined by, commentators as an original solution of a technical problem, right? That's an invention. And that's what it is applied when it comes to assessing the inventive step. We need to define the object problem to be solved first. So patent offices, when it comes to assessing the inventive step requirement, they need to first define the objective, the problem that needs to be solved, and then the assessment of whether the skilled person in the art would have arrived at the claimed solution, achieving the same effects which are ascribed to the invention, right? So, for example, this was a case of a few years ago in Europe, at the European Patent Office. It has to do with the one-click system developed by Amazon, no? You may be aware that when you buy on Amazon, you just click on checkout. But the first time you subscribe, as a user, you insert your details, name, and more importantly, the addresses, and more importantly, of course, the credit card details, right? Well, then when it comes to making the subsequent purchase, you just click once, one-click system, right? So the Board of Appeal of the European Patent Office, in this case, had to decide whether the one-click system developed by Amazon was patentable and in particular satisfied the inventive step requirement. Well, the European Patent Office said, no, the invention in question, the one-click system, is not inventive enough, does not satisfy the inventive step requirement. Why? Because the person skilled in the art, in this case, the person skilled in the art would be an expert in cookie technologies. Cookie technologies are those, technologies which help in finding out the footprints we leave on the internet, right? Cookies. So an expert in cookies would not be, for an expert in cookies, would be obvious. It would be obvious to reach such an invention. It would be too obvious. That's why the patent office in Europe refused the patent in this case, right? So you can see how the novelty requirement, the novelty requirement is different from the inventive step requirement. In the case of novelty, what a patent examiner does is to look back at the state of the art and try to find whether there is an identical invention which has been disclosed before the filing date, the filing of the application. If there is an identical invention which was disclosed before, there is no novelty. In case of inventive step, the examiner still looks back at the prior art, but in this case, she doesn't look for an identical invention. She looks at the state of the art, at the similar state of the art, in order to verify whether the invention in question departs significantly from such state of the art. If there is an enough inventive step, right? So there are differences between novelty and inventive step. Then there is an industrial application requirement, which does not really raise very important issues. The industrial application requirement means that the invention needs to be workable in any kind of industry, including agriculture. Right? So very, very simple requirement, I would say. But then we have another requirement which has not to do with the inherent characteristic of the invention, right? Invention could be in the mechanical field, in the engineering field, like all electrical, pharmaceutical, biotech field, medicines. I mean, there are several technological fields where you can file patents, right? But when you file a patent application, you need to disclose the invention in a manner which is complete and clear enough to allow a person skilled in the art to reproduce it, right? And the failure to comply with this disclosure requirement means that the invention will not be patented. But why is it important to disclose the invention in a manner which is clear and complete enough for the expert in the field, the skilled person in the field, to reproduce the invention? Well, first of all, the main aim is to prevent applicants from keeping confidential certain information regarding the invention which are necessary to understand it and to reproduce it, right? At the end, as we will see later on with the presentation of delivered by May, we will see that patents aim at stimulating innovation and more broadly to make sure that after the monopoly is finished, the patent is expired, normally it's 20 years after the filing of the patent application. The aim is to make sure that our technological progress goes forward, because after 20 years, the patent falls in the public domain, the invention falls into the public domain, and everybody is capable to use it, to exploit it commercially. But if you have not disclosed clearly the invention in the patent application, how can the society at large, at the end of the patent term of protection, take advantage of the invention? You need to disclose it. That's why the disclosure requirement is important, right? Then what we have also in several patent statutes, I'm thinking about the European Patent Convention, for example, is a list of inventions that, or subject matter in general, that cannot be patented for various reasons. So here you have the list, for example: discoveries, scientific theories, mathematical methods, aesthetic creations, schemes, rules, and methods for performing mental acts, for performing playing games, methods of doing businesses, and also software, programs for computer, which are software, and in general presentation of information. So why should these subject matter be excluded from patentability? Why should we exclude from patentability discoveries, for example? Well, discoveries are not invention. Invention is something that you create from scratch or something that you improve, right? There is a material which is added to the existing body of knowledge, right? Something which is created, which is improved, which is added. When you make a discovery, you just discovered something which already exists. That's why you don't deserve a patent there. Discoveries in several countries, not in the US, but in several countries, discoveries are not patentable. Scientific theories and mathematical methods cannot be protected because they are theories. There is no technical effect. Patents are all about technology, technical effects. And then you have aesthetic creations, right? Aesthetic creations cannot be protected either. There is another intellectual property right that should be secured in order to protect aesthetic creations. This is copyright, right? Not patents. Patents protect technology. As I said, software cannot be protected by a patent. Usually software, for example, the source code of a program is protectable by copyright as if it were a literary work, a book, a poem, an article. But this is protectable by copyright, not by patents. However, if a software does have technical effect, well, those technical effects produced by a software can be protected by patents. This is inferred by this provision of the European Patent Convention, because all this subject matter cannot be protected by a patent if they are interpreted or present as such. So discoveries, software, scientific theories, mathematical methods are excluded from patentability as such, which means that if a discovery has a technical effect, if a software does produce a technical effect, if a scientific theory is capable of being applied to a specific certain field of application, and it is capable of producing technical effects, well, in these cases, yes, patents are available to protect those technical effects, right? Let's move on and let's talk about another intellectual property right, secrets. Usually, when it comes to developing a technology, a company, for example, which spends huge resources in R&D, in research and development, right? Companies like these do have two options in order to protect technology which has been developed. The first option is to file a patent application, as we said before. You file a patent application before many patent offices, for example, US Patent Office, Indian Patent Office, European Patent Office, Japanese, Korean Patent Office, in order to get protection in those jurisdictions. But, as I said before, the application will be filed, and if the invention is patented, if the patent is granted, you will have protection for 20 years, right? After that, the invention will fall into the public domain. There's no protection anymore. No protection anymore. So there is a kind of, downside here. After 20 years, you don't have protection anymore. The second option you have when you develop technology is to try to exploit the technology as a secret by keeping it secret, right? In this case, the protection is potentially perpetual, is potentially forever, as long as the information is kept confidential, right? And these are the requirements for acquiring and keeping trade secret protection in several countries of the world, because what I'm reading now is a provision of the TRIPS agreement. The TRIPS agreement is an international agreement concluded 26 years ago under the auspices of the World Trade Organization. Well, Article 39, paragraph 2 of the TRIPS agreement tells us that all countries of the WTO are obliged to protect information that is secret, that has commercial value because it is secret, and has been subject to reasonable steps to keep it secret. So these are the three requirements that we are now going to analyze more in depth. So first of all, this is the first time trade secret protection with the TRIPS agreement was protected, was envisaged in international treaty. And of course, the protection was modeled following the US legislation on that, as it happened with several intellectual property rights at global level. So the first protection, the first requirement for protecting confidential information is that the information should be secret. It's quite obvious. If it has been disclosed to someone, if it is being published on a website, on a journal, it's not secret, so it cannot be protected by relying on this provision. That's quite obvious, right? So the information as a whole. So here I have inserted some examples of academic examples of trade secret, the Coca-Cola formula, right? It has been secret and is still secret. It has been kept secret for several decades, more than 120 years. The Nutella process of manufacture, it's a secret as a whole. But then the information which is kept confidential may also be composed of individual pieces of information that may be in the public domain. They might be in the public domain. So individual pieces of information might be in the public domain, but the compilation of such information, the putting them together, might not be in the public domain. For example, the client list of a bank, of a law firm, right? So let's remember, secrets not only protect secrets laws, not only protect technology, but also other kind of information, which is not technological information. Could be the list of clients, any kind of information which is valuable, not only technological information, right? Then, as a second requirement, the information, whether it is technological or non-technological or whatever, should be of commercial value to its holders or competitors. And this value would be lost or impaired if the information ceases to be secret. So, another strong requirement, another quite important requirement is that the information should be of commercial value because it is secret. You can see how here the protection is granted because of the commercial value of the information. It's a kind of commercial protection, right? For example, the marketing plans of a company. That would be a non-technological form of confidential information. In the case of Coca-Cola, of course, it's a technology. No? The formula was invented more than 120 years ago. What the trade secrets law protects there is the technological solution, how the company came up with that formula. Then, third requirement for protection, the information must have been subject to reasonable steps by the person lawfully in control of the information to keep it confidential. And here, if you don't take steps, reasonable steps, to keep the information, the technology confidential, well, you cannot invoke protection from the law. Reasonable steps. The concept of reasonableness may vary, may be different, may be based on the nature and value of the information. Right? Depends on a case-by-case basis, basically. For example, a quite reasonable form of keeping a technology confidential is encryption. No? For example, and especially for electronically maintained technology information which is stored electronically. Encryption is a reasonable way to keep it confidential, right? In the old days, when computers were not around, people used to use, and companies used to use safes Well, even the Coca-Cola formula at the end of the 19th century, when it was invented, it was kept in a safe for many decades, right? Or what can be used also is the division of works. Employee A deals with some information, employee B deals with other information, employee C deals with, and so on and so forth. So the information as a whole is confidential because employee A does not know what employee B does, employee C does not know what employee D does, and so on and so forth. And then another way to keep it confidential, of course, is a contract, the so-called NDA, non-disclosure agreement, a contractual restriction. Here, the company which wants to keep confidential certain information will have all its employees sign an NDA, a non-disclosure agreement. Any kind of partner which enters into contact with the company will need to sign an NDA if they come to know some aspects of the secret technology. This is the contractual way of keeping an information confidential, which adds a further layer of protection, not only and not just trade secret protection, a tort protection, but also a contractual protection, a further double layer of protection. Okay? So once protection is obtained, which of course is not a registered right, it's not like a patent here, you don't file an application, it's secret, of course, it's a kind of unregistered right. So you get protection, what can you do? You have the right to prevent other people from disclosing, acquiring, and using information by third parties in a manner which is contrary to honest commercial practices. A footnote to that Article 39 TRIPS provision gives us a list of unfair practices, both contractual and non-contractual unfair practices. For example, breach of contract, breach of confidence, inducement to breach, acquisition of undisclosed information by third parties who knew or were grossly negligent in failing to know that such practices were involved in the acquisition. Okay. This was as far as patents and trade secrets are concerned. I also want to add something with reference to copyright, right? So we go back to the slides on copyright, because also copyright might be relevant to the engineering field. For example, I'm thinking about engineering drawings, right? Engineering technical drawings. We know that engineering drawings are technical, right? But in most jurisdictions, I would say, engineering drawings are protected by copyright as artistic works, because that's what copyright protects mainly. Copyright protects artistic works, musical works, literary works, and other kinds of works, right? What is quite relevant when it comes to engineering is technical drawings, and technical drawings are protectable by copyright. So, which are the requirements for protection, for copyright protection? The first important requirement is originality. Works, for example, paintings, but also technical drawings, they should be original in order to attract copyright. Well, the concept of originality is different from country to country. is different from country to country. For example, in Europe, we have the European Union, at least we have an intellectual creation test. Everything which is the result of an intellectual creation, such as an engineering drawing, is protectable by copyright. In the UK, we have a skill, labor, and judgment test. Everything which employs skill, labor, and judgment, the outcome of these is protectable by copyright, and so on and so forth. So we could say that the level of originality required is quite low, right? It's quite low. Very similar to the concept of originality is the concept of authorship. In especially human authorship. We have copyright. Copyright is protected, is granted and protected if there is a human author. For a literary work would be a person writing the poem. For an artistic work would be a person actually drawing the work, the engineering drawing. If it is a musician, a singer, a person writing a melody, and so on and so forth. We need a human being in order to get copyright. So, if there is no human being, that is to say, if the work is done by not a human person, but for example, by a monkey, could be copyright protected? Well, I have inserted this picture of a monkey, not on purpose, because that was a case of a few years ago in America. Well, the case originated in Indonesia. A British professional wildlife photographer was, taking professional photographs in the jungle, in the forest in Indonesia, with all his equipment, blah, blah, blah. What happened was that a monkey, a macaco, to be precise, grabbed his photograph and started taking selfies, right? One of which is this selfie. So a litigation followed especially regarding the issue of ownership. Who is the owner of the copyright over this photograph? Is it the photographer who had prepared the cameras, the equipment? Or is it the monkey? Can animals be owners of copyright? So can animals be authors of a work and then owner of the copyright over such a photo? Well, there was litigation in America started by the photographer and also here a part to the proceedings was an animal rights organization in America, which claimed that the monkey was the owner of the copyright and that the animal organization was taking legal action on behalf of the monkey. Right? Of course, the American judge did not agree. Did not side with the animal rights organization, and they said no. Animals cannot enforce copyright. It was more an issue of enforceability more than authorship, I would say. But of course, also the court suggested that the animal cannot be considered an author either, right? Well, the same kind of issue was and is quite relevant when it comes to artificial intelligence. We already know that nowadays artificial intelligence, machine learning, is capable of producing outputs, right? Of producing outputs. This is an example. The Rembrandt Project. You know, Rembrandt was a Dutch painter, a maestro, one of the best. What happened was that a group of Dutch researchers set up a machine learning equipment, also equipped with 3D technology capabilities, and they were able to recreate, right? The machine learning here was capable of recreating, of coming up with the next Rembrandt, another Rembrandt. So what happened here was that the machine learning was fed with all paintings by Rembrandt, so was trained basically by being fed with the Rembrandt paintings to come up with the next Rembrandt. But the programmers, the researchers who developed the machine did not have any clue of how the machine would end up in this painting. So the way the machine worked was unpredictable. So here the issue is, who is the author? Is there really an authorship requirement being satisfied here? Because there is no human author. Well, there is a human author who is the programmer, the deviser, or the user of the machine, which then comes up with the copyrightable output, or the output. Whether this copyrightable remains to be seen. It's an open question. So the issue of authorship here is doubtful. So there are doubts about whether authorship is satisfied, the authorship requirement is satisfied. There is also a doubt whether the originality requirement is satisfied here. Because the way the originality requirement has been interpreted in several jurisdictions, I'm thinking about Europe, for example, several European countries, in particular the European Court of Justice. Well, the way the originality was interpreted is an intellectual creation, a personal touch of the author. Well, how can we say that a machine does have a personal touch? Does produce an intellectual creation, right? There are some doubts which are not resolved yet by the courts, by the case law, not even by the legislature, by the lawmakers. So we still need to find a solution to that, right? So I thought it was important to present this intellectual creation, this artificial intelligence example. Another requirement for copyright protection is in some countries, not in all countries, but in some countries such as UK, US, and several common law jurisdictions, is the fixation requirements. A work needs to be fixed in a tangible support, in a tangible media. For example, a painting is fixed into a canvas, right? An article, a journal article, is fixed on a computer. Or if you write handwriting, it's fixed on the paper. There needs to be a tangible medium fixing the work. If there is not, in these jurisdictions where there is a fixation requirement, well, there is no copyright. The fixation requirement is not satisfied if there is no recording, let's say. So doubts remain whether the fixation requirement is satisfied by certain works. I'm thinking about environmental works, gardening art. Here, the plants which form the work might change due of nature, due of weather elements, right? What about a sand castle? Is a sand castle fixed enough? It's quite, let's say, ephemeral. It's a nice sculpture. Fixed enough? Well, there are doubts about that. Makeup. What about makeup? This actually was a case in England in the 80s. Is a makeup artwork, because makeup are for sure artworks. Are makeup artworks copyrightable? Are they fixed? Well, a judge in the 80s said no. A judge in England in the 80s said in this case, in the Adamant cases, no. A makeup is not a painting because it goes away with the wash. That's very interesting. So these are just a few, examples of fixation requirements being doubt. I mean, of works that whose fixation might be, might raise some doubts as far as the fixation requirement is concerned, right? A couple of years ago, the Court of Justice of the European Union was also asked to rule whether the taste of a cheese could be considered copyrightable. Well, the Court of Justice of the European Union there said, well, since the taste is quite subjective, is not objective, it may change, the way, well, it's not copyrightable. So, suggesting that here the fixation requirement was not satisfied. Okay, let's conclude the last 10 minutes of this presentation by talking about the other intellectual property rights, in particular trademarks and designs, which are probably less relevant for engineering, because let's be honest, for engineering field, what is really relevant are patents, trade secrets, manufacturing secrets, and of course copyright. Copyright, which also protects software, right? Copyright protects the source code, which is quite relevant for the engineering field. But let's now talk about trademarks. Here I have inserted many slides, but probably we will skip many of them, and we will focus on the main requirements for trademark registrability, let's say. Let's say trademarks, right? First of all, as Ms. May will tell you later, trademarks have the function of distinguishing the products of a company from the products of competitors, right? Trademarks are registrable, although there are forms of protection for unregistered de facto trademarks, but usually trademarks are registered, right? But there are grounds for refusal of registration. So again, you apply for a trademark registration with the trademark office. If everything is correct, you get the registration at the end. So let's now briefly analyze the grounds for registration, for refusal of the registration. The absolute grounds for refusal, the grounds that are usually raised by the trademark office. Lack of distinctiveness. A trademark shall be registered if it is distinctive. Right? What does it mean? For example, what do you think? This logo, the logo of an apple, it's a very famous trademark, right, of the company Apple. Well, this logo is very, very original. It's very distinctive. Why? Because the logo Apple with a bite has nothing to do with the products upon which the logo is affixed. What's the relationship within an apple between an apple and a computer. They are very distant concepts, fruit and computer. So the bigger is the conceptual distance between the brand and the product upon which the brand will be affixed, the more distinctive, higher will be the distinctiveness. The more distinctive will be the sign, right? On the other hand, if I am a shoemaker and I go to the trademark office today and I try to register this logo, the logo of a shoe in relation to shoemaking, the trademark office will for sure refuse the registration because it is not the brand, the trademark is not distinctive. It is not capable of distinguishing these products, shoes, from the other ones. I mean, there is also a public interest ground behind this prohibition, the prohibition on the registration of descriptive, non-distinctive brands, right? And the ground, the public policy ground is we need to avoid the registration and therefore the monopolization of one trademark in the hands of just one company, because intellectual property rights are monopolistic rights, are monopolies. If you get the registration over this logo of a shoe, you will be the only shoemaker being capable of using such shoe logo in connection with shoes. And this is not fair. We need to guarantee that all the other shoemakers are capable of using in their own business the logo of a shoe to describe what they're doing, that they are shoemakers. So the distinctiveness, the distinctive function, the distinctive nature of the trademark is the most important requirements for getting trademark registration, right? Let's remind this. And finally, I want to skip these slides because we don't have time, but I want to say just a few words on the last intellectual property rights I talk about today, which is design rights, industrial design. What do we mean by industrial design? What is the industrial design right? Well, industrial designs rights protect the ornamental feature of a product. So if you have this bottle opener, for example, you see this bottle opener, the function of this bottle opener is to open bottles. However, these bottle openers does also have an ornamental function. You can see the way it has been devised is very ornamental, very aesthetic. So that's what this intellectual property right protects, the ornamental feature. And I conclude with this, countries in the WTO may choose between a novelty and the originality requirement. It's up to the countries. So I have finished here. I hope it has been useful. And the floor to you, Jazila.
Yes, sir. Thank you so much. And without any delay, we'll move on to Ms. May Hassan. Ma'am, are you online?
Yes, I am.
Yeah. And just stop this and we can go. Okay, ma'am, all to you. We may begin. Thank you.
First of all, I want to thank Mr. Enrico for the presentation.
Excuse me, ma'am. Ma'am, can you be a little more audible? Your audio is a little low.
My audio is low?
Yes.
What about now?
Yes, it's clear now. Thank you so much.
That's better?
You may continue. Thank you.
Okay. So, first of all, I want to thank Mr. Enrico about all what he have covered about intellectual property. As we have said before, what I will actually cover today is what is intellectual property, what are the intellectual property rights, the importance of intellectual property as well as the types of it, and the key characteristics. We will also cover the intellectual property mindset, which is something that's really important and that I really want to talk about today. So first of all, I want to start with this quote that shows the importance of intellectual property nowadays. So this is Mark Getty, and he actually said intellectual property is the oil of the 21st century. He said, look at the richest men 100 years ago. They all made their money extracting natural resources or moving them around. But all today's richest men have made their money out of intellectual property. And this shows the link between intellectual property and money and how you can actually gain money out of it. So what is intellectual property? Intellectual property is the intangible creations of the human mind or intellect. And these intangible creations can be anything you can actually think about, like inventions, artistic works, images, literary works, designs, samples, software, books, music, movies, know-how, and actually the list goes on. All these intellectual aspects are actually valuable, intangible assets. And because they are so valuable and at the same time so intangible, they needed to design a system to actually manage it. And this system is actually the intellectual property, and actually it's integrated and designed to protect all these intangible assets. And this is why they have created the law of intellectual property to manage all these assets. And this law grants what we call about intellectual property rights. And the intellectual property rights are actually exclusive rights given to persons over the creations of their mind. And they actually enable persons to protect their creations for a limited period of time. And they also enable this person to earn recognition and financial benefit. So if you want to say what is or what are intellectual property rights, they are rights that exclude others from making, using, offering for sale, or selling or importing the creation of invention. And this is why they are so important. So if we think about, again, why intellectual property is that important and why intellectual property rights are really crucial nowadays. First of all, it's because they foster innovation, because if you do not have the intellectual property right, usually you will not actually have the incentive to create or innovate anything. It also gives recognition in the market, because if without it, you will not be able that this person who actually created this, or this company who actually produced this product or made this service. So give a recognition in the market. It also gives protection. And protection is very, very, very important, because without protection, you will not be able to go to the court and say, this is mine, when any infringement or anybody stole your creation or your innovation. It also can give you financial benefit, because now if you have the intellectual property right, you can sell it, you can use it, you can manufacture it, and you can gain financial benefit out of it. It also can be used as intangible capital, and this is very important because usually people think that the tangible capital, which is the money and the capital of the company, for instance, or the machines in the factory, or this tangible the capital are the ones that are being sold when there is a merger or acquisition or anything. But the truth is the intangible capital nowadays worth a lot more, but even millions, a lot more than the tangible capital. It also gives added value to each product. If you actually go and buy a branded product with a very well-known, famous brand, you will actually buy, it will cost more than an unbranded brand, or an unbranded product, or a product with a very not really known trademark. So trademark are really crucial as well. So what are the types of intellectual property? So there is the patents, the utility models, industrial designs, the trademarks, the copyrights, related rights, the geographical indication, the plant variety, and the trade secret. And actually, these are all the types of intellectual property, but mostly in most of the countries, they really concentrate on the patents, trademarks, industrial design, copyright, and trade secret. And the rest, they do not really put it in consideration as these, as the other types. So let's talk about a quick fact that will really let us think about how intellectual property is very important. So first of all, I want to apologize for the fonts. It's not really as it should be, so the slideshow is not really working accurately. It will be better that we made the share screen than this. So as you can see,
sorry to interrupt. Ma'am, you may share the screen.
In 2018 only, there were 3.3 million patents that were actually filed and 2.1 million utility models, 14.3 million trademarks, 1.3 million industrial designs. And it's been 9 years that all these applications have been increasing day after day. And this shows how the world actually value intellectual property and how it's really, really crucial these days. Asia alone has exceeded 2/3 of applications worldwide and received the highest numbers of applications for patents and utility models and trademarks, as well as industrial designs. And so this actually, if we relate the intellectual property with the economic growth of each country, we will see how intellectual property is actually very, very, very related to it and connected to it. And the more there is intellectual property actually growing or increasing in a country, the more its economic growth actually increase as well. So let's talk about each type of intellectual property and what it's more about. So you will know if you have a creation or innovation, what type that will actually suit you and will actually help you to make a review out of it. So the first thing we'll talk about today is actually patents. And patent is old as ancient Greeks. The ancient Greeks actually granted protection to innovators in 500 BC. So it's as old as this. And a patent is actually an exclusive right granted for an invention. So it could be like for product and also for process. I want to stop here, and I was wondering if you can share my screen better than actually this, Gisela,
Yeah.
if you are here, if you are hearing me. Can I actually share my screen, because
it will be better.
the font is not really as I expected.
Okay, fine. You can share your screen. Sure, ma'am.
Okay. Okay. So it will take 1 minute. Exactly, yeah.
Or you may just right on top, you have option to turn your screen share on.
Yes,
so
this is what I will do right now.
Yeah, fine.
Is it shared now? Is it share? Let me know when it's actually on. So here it is. Is it working right now?
Again, if we upload, it would come back the same. So it will be better if you share your screen.
I'm sharing the screen right now.
I think it hasn't. Okay.
So it's not working, sharing the screen?
No, it is. You have to turn on right on top.
I just did that.
Okay,
and
then I'll just stop the slide.
screen.
And Now you may share the screen so that will be more clearer.
I'm sharing it now, but it seems that it's not working as well. Okay. It's not working. Okay, let's go back to the slides if it's not working. Fine. So we were saying that patents are actually the exclusive right granted for an invention, and this invention could be for the product, and also could be it could be a product, or it could be a process. A process could be a new way of doing something or a new technical solution to a problem, and of course this is very, very relevant to engineering. The patents encourage new technologies and the development of innovations in all fields, not only engineering, but every field. And their criteria, as Mr. Enrico said, there is the novelty, patentable subject matter. It should be a patentable subject matter. And also the non-obviousness, or the inventive step. Also, it should be capable of industrial application. Without these four, you will not be able to actually apply for a patent application. So what are the key characteristics of patents? The first thing is actually the disclosure. And the disclosure is actually saying what is your patent about, how did you create it, everything about your patent, its composition and everything, which you can actually write as something that we call patent claims in the patent application. The examination of a patent usually takes 4+ years. So it really takes a very long time to examine a patent, whether it would be patentable or it would be refused. As the duration of protection takes 20 years from the date of application. As you can see from this graph, that the most applications were actually filed in China, and followed by the United States, then the Japan, then the Republic of Korea, and then the European Patent Office. And this is why, again, there is a big relation between intellectual property rights and the economic growth of the country. So what if the invention didn't meet the patent requirements that you have mentioned? So we said that it should have this novelty thing and the inventive step and the industrial application and so on. What if it didn't meet? What you will do? Will you actually, stop, do not actually apply for anything? Or there is other type of intellectual properties that may help you and may support you? So there is the utility models, and the utility models actually is an exclusive right granted for an invention as well. And sometimes we call it petit patents, and sometimes we call it innovation patents. And utility models are very good for many engineers and for many innovators in general, because it has less requirements. It doesn't actually require an inventive step, but more like the novelty. And it's much cheaper, like the application is much cheaper. It's cheaper to obtain, it's cheaper to maintain, but the protection is less. Of course, it's not 20 years. It's actually from 6 to 10 years based on each jurisdiction. So another type of intellectual property right is the trademark. A trademark is a sign, and this sign is capable of distinguishing the source of products. And these products could be either goods or services. So a trademark, as you have seen also in Mr. Enrico slide shows, that it could be anything. It could be figure, it could be pattern, it could be symbol, shape, word, number, 2-dimensional or 3-dimensional. It also could be scent and motion and sound, but not in all countries. Many countries do not actually accept a sound trademark or a motion trademark, or even a scent trademark. but for instance, France do accept some trademark, like some perfumes, they do actually accept it. Here in Egypt, for instance, we do not accept sound trademark. We have to see it by our eyes. Trademark has to be seen by our eyes. But in other countries, you can actually register a sound trademark, which is like the beginning of, you know, any for instance, if we say a movie, at the beginning there is this sound that actually can be thought by the production company, and this sound is actually a trademark for this company. So these are some examples of trademark, like Facebook, Samsung, 7-Eleven, Walt Disney, and you can see here some of them are good, some of them represent goods, some of them represent services. And there is the Louis Vuitton pattern here. And also it could be three-dimensional, like the shape of a bottle or something. So what are the types of trademarks if we will talk about? So there is the trademarks, the general trademarks which distinguish the goods, like the products of, you know, the Apple companies, the laptops, the cell phones, and so on, or the products of Nike, like the shoes, the sportive clothes, and so on. There is also what we call service marks that distinguish the services. For instance, Google, they give us so many services like the email, the YouTube, the drive that you can, you know, upload your documents. Amazon.com also gives a service. We can actually browse some products and actually buy it online. So this is kind of service. There is also what we call the collective marks. And collective marks distinguish goods and services by member of an association. So you actually, there is this association that has this trademark, and all the member of this association has the same characteristics, or for instance, they are interested in the same thing. Like the Wild Foundation, they actually are, all of them are interested in animals and protection animals. Oxford University Press, all of them are actually interested in press and so on. There is also what we call the certification marks. And the certification marks distinguish products verified according to certain standards and certain criteria or certain regulations. And this is why people tend to actually buy a product than another, because it actually has this certification mark, because it gives the customer a kind of like this product is safe because it has this certification mark, so I actually buy it. And the last thing is what we call well-known trademarks. And well-known marks were actually at the beginning either a trademark or a service mark, but they gained reputation and they started to be very well known around the world, and this is why they started to be well-known marks. And the well-known marks or brands are actually, they get a lot of benefit than any other trademarks because they actually have stronger protection. They can be protected in some countries even if they are not registered. So they are pretty unique, and they are not like the other trademarks, like Coca-Cola, for instance, or the Mercedes-Benz trademark. So what are the key characteristics of a trademark? The first thing is that when you go and register a trademark, you actually register either for products or for services. And you have what we call classes. So there is 45 classes, and there is 40 classes related to goods and 5 classes related to services. And usually you actually apply for either 1 or 2 or 3 or even 5 or even a lot more than different class. So this is one of the key characteristics of a trademark, that it can actually represent not only goods, but it can represent goods and services in the same time. The second thing is the examination. The examination of the trademark usually takes from 6+ months to 1 year to be examined. So the trademark office say, yes, this is accepted or not accepted. And this depends again on the criteria that Mr. Enrico has said. There is some criteria that without it, a trademark can be refused by the trademark office. Like for instance, if the trademark is descriptive, Like if I say we have the apple trademark and I am selling actually apple, fruit. If I do this, it will not be acceptable. Or if I am actually saying flower and I put my trademark and name it flower, even in another language, fleur, for instance, in the French language, it will actually refuse. Why? Because it's descriptive to the product and service. So it's very important to put this criteria in our mind while creating and while creating the logo, for instance, and while innovating something that's related to patent also. For the duration of protection of it's 10 years. And actually, these 10 years could be renewed for another 10 years, another 10 years, and another 10 years. So, and you have to actually renew it the 6 months prior to the expiration date of the registration. And this is very important to actually put it in our mind, because the trademark is actually the most intellectual property right that is long-lasting. Most of the intellectual property rights are very limited in duration. They are protected for a very short time, but the trademark is not like that. The trademark can be protected for lifetime as long as you are renewing the trademark itself. And this is why most of the pharmaceutical companies, for instance, when the patent expires, they make sure that the name of the patent is a trademark, so that it will actually continue to be with them and to have the loyalty of the customer for the name of the trademark. So even if this patent is expired and is actually in the public domain, customers will actually continue to buy the same product because they are loyal to the mark of this invention. And so it's very important to know how trademark is actually play a great role by letting people continue to buy the same thing despite that it's actually in public domain. The third type we talk about today is the copyright. So what is copyright? Copyright is an exclusive right granted to creators of literary and artistic works. Like what? Like books, paintings, sculptures, drawings, like music, films, documentaries, computer software, databases, mobile applications, designs, advertisements, maps. All these are actually many examples of copyright. And there is something very important to mention here, that, for instance, for the computer software, for the computer programs, it's probably protected under copyright in many countries, but in United States, for instance, it's protected under the patent and not copyright. So it's really important to know which country actually, which intellectual property right it's protected, or where it's protected, in which category it's protected in each country. So if you are actually selling your product in the United States or selling your software in the United States, you have to actually patent it, not actually copyright it. But if you're selling in another place, you will have to copyright it. You have to know the difference, because there is a big difference between a patent and a copyright, not only in requirements, but actually in the terms of protection and the duration of protection. So what copyright give? The copyright give mainly economic rights, which allow the rights owner to generate financial benefits from the use of their works by others, like having money out of it. And it also gives what we call moral rights, which protects the non-economic interests of the author. Like what? Like, for instance, if someone actually started to play in the context of a book or delete some paragraphs or say something, include some not good words in the middle of this book, all this actually is protected by the moral rights. And the main difference between the economic rights and the moral rights is actually that the economic rights have a limited duration of protection, but the moral rights last for the lifetime. So even if the economic right is expired, the moral rights remain forever, because I want to make sure that the author or the creation of the author will not be affected badly by any person like someone will actually play in the context of this creation and make it worse. So what are the key characteristics? First of all, the publication. The copyright is granted to the authors of original works of authorship, both published and unpublished. And this means that even if you actually do not publish the work, this doesn't mean that it's not protected. It's still protected, even if it's unpublished. So once you create this, anything that we have mentioned, they create this drawing, you create this software, you create this book. Once you create it, you actually have a protection granted to you. It's automatic protection, and it doesn't have to be published. The second thing is the duration of protection. The duration of protection actually vary from country to country. In India, it's actually 60 years. It's actually the life of the author plus additional 60 years from the moment of its creation. In most countries, there is other countries that actually, again, protected for the author's life plus 50 years, and other countries plus 70 years. So it's actually always the author's life plus either 50 to 70 years. And for the registration, as we have mentioned, that the registration is not required in many countries because the protection is granted automatically. But if you are making a very important work and there is really a big chance that this work will be stolen or that something like there is an infringement that may happen, it's better that you register it, because it's better that you will have a proof that actually say that this is yours since this date. If you do not have this proof, you will probably get into trouble and you will not be able to prove that it's yours or that this work is made by you. So it's very recommended that you register it, even if registration is not required and even if the protection is automatic. Now here is the related or neighboring rights. And the related rights is actually rights related to copyright. They are the rights of creative work, but they are not connected with the works of actual author. So what do I mean by this? Related rights could be right of performers, like singers, for instance, or dancers, right of producers of phonograms, right of film producers, or right of broadcasting, publishers, producers of databases, and so on. So as you can see, for instance, the right of the performer did not write the song. The lyrics of the song. He did not compose the music of the song, but actually he has performed it. So it's a right related to copyright because it's related to the song, but it's not connected to the author work itself, to the original work, because he did not write the lyrics, he did not compose the music. And same case for the broadcasting, for instance. So when you broadcast something, you didn't create the original work, you are just broadcasting it. You didn't create the scripts, the film, the movie script, for instance. You didn't write it, but you are actually producing the film. So these are rights that are always related to the copyright, but they are not actually connected to the original work. The key characteristic of them that the duration of their protection is usually 25 years for broadcasters and performance rights, and it's really differ from country to country, from 20 to 25 years, maximum 50 years. So it really depends on jurisdiction and country as well. Now we will move to the trade secrets. Trade secrets are actually information that have inherent economic value. So they have an economic value, and this is why they are intellectual property right, or we consider it as intellectual property right. But they have key characteristics, and this is very also important. So here are some samples of or examples of trade secret. A trade secret could be formulas, designs, patterns, could be a know-how or a practice in a business or a process that you have created, or a list of clients, for instance, in your business. It could be also an instrument or some patterns and designs. And you usually keep it secret because of its economic value. Some example of this of real life is actually the Coca-Cola recipe and the KFC recipe. Both of them are actually trade secret. The Coca-Cola is until now Coca-Cola, not only because of its brand and its trademark, but because of its trade secrets that nobody actually know how Coca-Cola is actually the composition of Coca-Cola. And they were able to keep it secret until this moment. So the first characteristic about the trade secret is that the owner must take reasonable measures to keep the information secret. If the owner do not take these measures, they will not consider it as trade secret. And the second thing, that the information should not be accessible or should not be generally known by the public or readily ascertainable by others. This is very important because if the information could be known by others with a way or another, it's not a trade secret anymore, and it actually loses the economic value of it. This is another type of intellectual property right, which is the industrial design. And I believe that the patterns, the industrial design, and the utility models, the three of them are very, very important in engineering. Because any invention has an appearance or has a certain shape or aspect. So industrial designs are really important. So what are industrial designs? An industrial design constitutes the appearance or the ornamental aspects of an article or an object. And it could be two-dimensional, like lines or patterns or a composition of colors, or it could be three-dimensional, like the shape of a product. So for instance, there is this shape of this glass. So this glass has a certain shape, and at a time it was actually protected as an industrial design until actually the industrial design were actually in the public domain, and anybody can actually create the same design afterwards. And it's actually protected for 10 years, but you can renew it once for additional 5 years. So in total, it's protected for 15 years. The geographical indication is another unique type of intellectual property rights, and it's actually connected to the origin of the source of any product. So a geographical indication is actually a sign, and it's used on products that have a specific geographical origin and possess the qualities or a reputation due to that origin. So for instance, there is this kind of cheese that is actually made with this taste. It's because it's actually made in France because of the way that they do it and the way the know-how that they actually, based on this know-how, they were able to make this unique taste that it's not typical in any other country. This geographical indication could be also on certain clothes or certain patterns that are actually unique and very, very related to the traditional knowledge of the persons in this country or the citizens in a country. So I can see that this show is a very, very, it is a geographical indication. It's very related to India. So these are samples. And in each country, there are different geographical indications because mostly there is many food, and mostly also they are related very much to the traditional knowledge and the traditional knowledge, the traditional expressions of the citizens of a country. There is also another type of intellectual property right, we call it plant variety protection. And this is actually a protection for new varieties of plants. So plant variety protection is actually an exclusive right, and it's provided to breeders of new varieties of seeds, tubers, and asexually propagated plants. So it should be new varieties, and this is why they actually gain the intellectual property right. And the period of protection depends on the type of the plant. So there is, for the field crops, it's actually protected for 15 years. For the trees and wines, actually protected for 18 years. And the notified varieties in general protected for 15 years from the date of notification. Some keynotes I want actually to talk about today. That, first of all, if we talk about registration, so registration, as we have mentioned, is very important if you are not only if you are fearing to let somebody steal your invention or steal your art or work or creation, but actually it's very important as well if you are willing to invest in it, to invest and to actually gain money, to have a financial benefit out of this intellectual property right. And there is two routes of registration. There is the national route, and this is actually the normal route, the normal thing. You actually go to your intellectual property, to the intellectual property office in your country. Usually they are separated, like for the trademark, there is the trademark office. So if you want to register your brand, you actually go to the trademark office to register it. If you have a patent, you go to the patent office to register it, and so forth. So the national route in each, you have to go to the intellectual property office in each country. But what if you are willing, for instance, to sell your invention in another country, and then you will need to register it in another country, which is very, very important, and it happened to many people. So either you will have to go through the national route, like go into each country or have a legal representative in each country, and then register your intellectual property right. Like for instance, if I want to register in India, I have to go to India to register my trademark or my patent, or I have to have a legal representative, like an attorney in India, an Indian attorney, to actually do that for me. Or I could have another option, which is a lot easier, and we call it the international route, and we do this through the World Intellectual Property Organization. So the World Intellectual Property Organization have different systems, so you can actually register your intellectual property right according to this system. So if you have a patent, there is this PCT system where you actually the international patent system, and you will go to the World Intellectual Property Organization website, and you will actually follow the the steps to actually register a patent. And you actually do that online, and you can actually register different patents in different countries in the same time with less, less fees. So instead of actually paying like thousands of dollars for the attorney and the same time in each country, this will really, really be very costly. So if you are willing to sell your product or to market your product or your invention in different countries, you have to put in consideration the international route, and to actually do it through the international route. So there is the patent system, as you have mentioned. There is also a system for the trademark, which is the Madrid system, the international trademark system. There is also another system for the design, for industrial designs, the HIDE system, the international design system, where you can actually apply upward to 100 industrial design at the same time. So you can see how it's very, very efficient and it will be very easy to actually register your invention or your trademark or your intellectual property right in general in different countries at the same time. And there is also the Lisbon system, which is the international system of geographical indication. But you have to put something in consideration while actually applying in all these countries at the same time. For instance, let's say you have a patent, you have an invention, not a patent, it's still an invention because it could be refused. So you have an invention and you want to have a patent, to be granted a patent. So you will go and use the PCT system, the International Patent System, through the World Intellectual Property Organization. And then afterwards, you will the World Intellectual Property Organization will actually send your invention or your patent application to the countries that you have selected. So let's say you have selected in 4 countries. The patent application will be sent to the National Intellectual Property Office or the National Patent Office of this country. And they will examine it. And it will take the 4 years. And probably either they say, yes, we accept this patent, or they will say no. They will refuse to this patent application. So once you actually apply for a patent application internationally, this doesn't guarantee that the national office will accept your patent application. It could be accepted in a country and refused in another country. It's the same thing for the trademark. It could be accepted in a country and refused in another country. Why? Because when, for instance, they examine a trademark, the national office actually, they go to their database. So if they find a trademark similar to your trademark in their database, they will actually refuse your trademark. Or if they found it descriptive, for instance, they will refuse your trademark. But if they actually find that this is not similar trademark, it's a new trademark, it's not in the same class, as we have mentioned, there is classes, now they will accept it. And by then, the WIPO, the World Intellectual Property Organization, will actually publish this online, and you will see all this database actually online, and you will see yours accepted online. Here I want to talk about the intellectual property mindset, and this is probably something very important to put in consideration. Why? Because I saw many businesses, engineering businesses even, who actually work on their invention and work on so many potential intellectual property rights, but they do not have the intellectual property mindset. And when they do not have the intellectual property mindset, they actually they fail at the end to use it or to gain any financial benefit out of it. So there is this quote by Stuart Dyson who said, owning the intellectual property is like owning a land. You need to keep investing in it again and again to get a payoff. You can't simply sit back and collect rent. So this means that you really need to invest. So how you will invest and what you will do to invest. So this is, because there is no animation, I want to start from up from the top, from idea, and then we will move with the clockwise. So first of all, you will have an idea. And you have to know that this idea, as long as it's an idea, it's not protected. So you cannot say that someone else has stolen your idea. Why? Because you didn't express it. And this is what we call fixation. Because you have to express your idea in order to have a creation and innovation. How it depends on what you will create. And once you have this creation or this innovation and it's expressed, now you have something that you can register it. and you will go and register it. Depends on your intellectual property right, where you will go copyright office, trademark office, patent office, etc. And after registering it, and the office actually accept this and not refuse it, you will have what we call intellectual property rights. And once we have what we call intellectual property right, we have to continue the cycle, because the problem is that many inventors and creators stop here. They register the intellectual property right and they stop. They do not continue the cycle, or sometimes they do not even register it. And when they register it, sometimes they do not continue the cycle. So the years of protection, which is like 15 years or what, 20 years or whatever, depends on your intellectual property right, they actually run, and this creation innovation actually fall in the public domain, and they didn't use it at all. So it's very important to, after registering the intellectual property right, to go through the commercialization and monetization phase. Monetization and commercialization is actually the idea of putting strategies, intellectual property strategies, that can actually generate financial benefit to you and can generate money to your business or to you if you are even an individual. And commercialization and monetization has so many types, and you cannot actually do that except if you actually had registered your intellectual property right. Why? Because through the commercialization and monetization, it can be stolen very easily. Even if you go to an investor and you have this innovation and you tell them, I need you to invest in this innovation of mine that I have created. If you didn't register it, you will not be able to say afterward that this is mine. The investor can actually steal your product or your invention or creation and actually do it on their own. So it's very important to actually register your intellectual property right in the countries where you will actually invest. Invest in general could be through partnerships with other people, through agreements, through contracts, through licensing, so whether it's an exclusive license or a non-exclusive license or a blanket license. There's so many types of license. It could be that if you have not have enough money to actually continue to work and develop and make the research of this intellectual property rights, you could actually sell it. So it's kind, again, of commercialization and monetization. So some company actually can see that this patent or this trademark will get, will make a lot of benefit to me, so they buy it. For instance, when Facebook have bought WhatsApp. So this actually shows why companies buy other companies. Because and including these companies, there is the intangible assets, which are the intellectual property rights, which is the trademark, the patents, etc. For instance, the WhatsApp, you can see that there is a WhatsApp logo, which is a trademark, and there is a WhatsApp software or mobile application, or software on desktop and mobile application on mobiles. All these are actually patent, copyright, trademarks that are actually intellectual property rights, intangible assets. And this is how the commercialization and monetization are actually done. And this is how you actually can gain financial benefit out of it. So I say, once you have an idea and you express it, you have to create and innovate for the sake to generate profitable intellectual property rights. You have to make the work at the beginning. When you create and innovate, don't just create it or innovate it, have this idea of just innovating and that's it. No, you have to make the work. What I mean by make the work, by searching before actually creating and innovating, making sure that there is no prior art or there is no actually someone who have created it before. And after you search and make sure of that, you start to put it and integrate it in your business plan, because there is in each step of the business plan, there are some questions that you have to ask yourself to make sure that intellectual property is actually right fit and it's fitting into your business, so you can actually generate profitable income afterwards. After actually integrating all the intellectual property strategies into your business plans, you have also to make the assessment and the evaluation. For instance, you can go and register your intellectual property right and so on, but you have to maintain it on the long run. What I mean by maintain it is that for patents, you have to actually pay an annual fee. So these are actually money that goes out of your pocket. For trademark, every 10 years, you have to renew it and so on. So you have to make the assessment and the evaluation. And there is strategies and there is a ways even for assessment assessment and evaluation of your intellectual property right. So you will know if you will continue to maintain it or if you will eliminate it and actually think about either create another one or focus on another intellectual property right or an intangible right that you have to make your research and development, for instance. So this is how I want to show that there is so many steps that you have to actually go for it, and that it's very important to go through all this cycle and not leave one of them. And even when you gain financial benefits, it's very important afterwards to make the assessment and evaluation each year or each 6 months to make sure that this intellectual property right actually worth to maintain and worth to make more development on it. Because many companies have actually failed to do this, failed to do this. And when they actually failed to do this, they were not able to compete in the market and continue their growth in the company. These are some resources that I have this information out, which mostly they are WIPO resources, the World Intellectual Property Organization. They have an amazing library. You have to go actually and get a look there. And thank you for listening. And there is this chat box. I am actually willing to answer any question that has been. If there is questions, I'm not sure what did they have to do.
We haven't received any questions yet, so hopefully they're clear with the presentations.
I'm sorry, can you repeat this?
We haven't received any questions yet, so
Okay.
I think they're quite clear with the presentations today. So it was very informative, and thank you so much.
Thank you. Thank you so much.
And also thank you to all the attendees who have joined us live as well as watching live on YouTube. And we have shared the files in the file section for the participants to download, and you can go through the material. And if any one of your friends or colleagues have missed watching us, you can watch us on YouTube, and do come and register for the upcoming sessions. And tomorrow we'll be moving on to session 2. And with this, we'll come to the end of session 1. And thank you, Ms. May Hassan.
You're welcome anytime. It was my pleasure. Thank you so much.
Thank you so much.
Thank you.
Thank
Bye.
you. Good day, good evening.
Have a good evening too.